This, so if you'd please identify yourselves and your clients at the beginning of your argument, that'd be appreciated. Each of you will have 20 minutes in which to present your arguments. Counsel for appellant, you'll be responsible to watch the clock and reserve as much time as you wish for rebuttal. Also, please keep in mind we've read the briefs and conference the case. With that, counsel for appellant, you may proceed.
May it please the court, my name is Stanley Murray, and I'm the attorney for the appellant, Vargas, who is the respondent to the lower court proceedings. I would like to reserve 5 minutes of my time for the The case that we're presenting to you today, Your Honors, involves denial of a petition to modification of the decision on child support. Order that was entered way back in 2010, which finally reached the final conclusion in 2017. The issue, your standard of review rather for this issue is going to be the abuse of discretion. As you know, there are certain circumstances that exist for an abuse of discretion, and the misapplication of the law, or that there's a lack of evidence to support the trial court's rulings. We think both of those conditions apply here. As far as misapplication of the law is concerned, the trial court should have made a finding in regards to the change of circumstances before proceeding to the best interest analysis. In fact, in its decision, the trial court noted, according to the Pritchett case, that, hey, I'm supposed to make a finding on change of circumstances first before I go to the best interest analysis. Somehow we got
Juxtaposed, yeah.
Where he did the best interest analysis but didn't pay any attention to the change of circumstances. On this record, there was significant and substantial change of circumstances since 2010.
Counsel, how are you prejudiced by that? The court's admitted sort of mixing that up. How are you prejudiced in the sense that the court went ahead and analyzed all the 403 best interest factors and then laid out its ruling accordingly?
Because the trial court used the best interest analysis to determine that there wasn't a change of circumstances. Focus was on the wrong issue. Focus should have been not on the best interest, but what had happened since 2010. So the court would have found, or should have found, that there had been a substantial continuing change of circumstances.
Let's assume, for argument, that if we were to agree with you that there was, in fact, that the court erred on finding not that a material change of circumstances had not occurred. Then what? What are you asking the court us to do? Is it just a simple remand saying the court erred regarding finding no material change of circumstances, start over? Or what exactly are you seeking?
We are seeking a remand and a new finding on change of circumstances and then a better analysis of the best interest factors that was occurring in this case.
What's that going to accomplish?
It's going to accomplish, hopefully, another reunification attempt that everybody asked for, but the trial court denied, you're saying.
And I'm maybe going outside the record here a bit, but okay, how do I phrase this? It seems to me like one party's over here, and one party's over here, and perhaps, as the court noted, I think, both sides, it seems, have a little bit of unrealistic expectations of what should happen here. Are there things that have been explored or that you would anticipate exploring that would be beyond just saying, let's put everybody in a room and do reunification again? Are there other things? Are there other tools that anybody has considered?
Yes, there should have been some sort of condemnation of the efforts of Mr. Gonzalez to alienate this child from my client.
Well, outside of that, we're realistic in terms of using professionals rather than the family court, or asking the family court to reach out to the juvenile court to find ways. You've got a 10-year-old or so who says he doesn't want the contact. You've got a mother who wants to embrace her child. And how do you get them to a place where they can say hello to each other in a very straightforward, not a terribly or overly expensive way if it's going to occur.
Well, that's where the trial court erred, we believe, by not allowing this reunification process to continue. The best interest attorney recommended it. Even Mr. Gonzalez, the father, wanted to do the reunification. Of course, my client did too.
I guess what we'd like to know is, in practical terms, what does reunification look like going forward if the matter is sent back?
Well, reunification should have been done as Ms. Ruelas suggested, where she said, instead of having father bring the child, a third party should bring the child to a different facility. That was the problem from the start, is that the fathers were interfering with this relationship. So Ms. Ruelas made a recommendation that don't let the father bring the child anymore. We've got to get some kind of participation by this child. So Ms. Ruskin noted that the father was interfering with the process. So on remand, if we could have a remand, the new trial court should order reunification without the father being involved, because he's been messing up, he's been interfering, impeding our,
Well, isn't he a necessary part of the process, though? The child lives with him.
and that's fine. My client is only asking for the reunification to take place so that she can build that relationship. She's not asking for 50-50 reunion unless father doesn't cooperate. If that happens again, he should be sanctioned in some form.
There's a couple of things I wanted to ask you about in the court's order specifically. The court found that it declined to, well, okay, arguably the court awarded some parenting time, I guess, but it's in father's sole discretion. So to me, that's really no parenting time. But nonetheless, that's what the court said, and the parties actually agreed, I think, or stipulated to a change in child support, saying that there was a material change of circumstances. But it's my understanding you did not challenge the court's that consent judgment on child support, right? That's not before us. Okay. Another point the court made was with regard to decision-making authority. The court said that parental decisions will be required for major issues, and that when they arise, father shall give good faith consideration to the views of mother and put forth best efforts to reach a consensus. And that also adds that with regard to medical and schooling, both parents will be provided with such input from physicians and educators. Is that occurring? What's your view of that provision in the thing? Is there any teeth to it? Is it enforceable?
Can I go off the record, Your Honor? I did speak to my client, and nothing's happening. It's not enforceable. It's not happening. And in regard to that recent case that came down, the case, I believe it's called, which said the court can't make a best interest decision if it's given sole decision-making to one of the parents. Father has the trump card. He gets to decide when this child gets to see his mother, and he's not doing it. So those orders that the judge has made in this case are basically a severance. The father got a severance after all. She doesn't get to see her son. He hasn't brought the son to meet with the daughter on the prior relationship that my client had, which was ordered in this order, by the way. And he hasn't done anything that he didn't do before, which was simply to keep mother out of the situation because he must have brought a severance. So these orders are ineffective, and they're definitely not in the best interest of the child, because under Arizona public policy, both parents are entitled to have a relationship with their child. This order doesn't meet that standard.
What is your client's position regarding the encouragement or suggestion, whatever you want to call it, the order that father, well, it does say shall encourage and facilitate the relationship between the child and his sister? Is that she is in favor of that?
Definitely. She just doesn't want father to be there. So it should be either a third-party supervisor or another family member. Because of that incident that occurred on the record with Ms. Gonzalez, where father came into the therapy session and got all the kids excited and agitated because he was so upset that mother was present. So we want father out of the picture as much as possible, but we do want that relationship to build between the daughter and his child.
Do you mean that you want father out of the picture initially, when there's initially reunification, or permanently?
Permanently, because the daughter has an adverse reaction to the father. She has no relation to him. All she wants to do is see her brother, and that's not happening.
Well, but mother has a connection. the daughter has a connection with her mother and no connection with father and is not related to her brother's father, correct? But isn't the other side of that coin that the child at issue here has a connection with his father and none with mother? So, I mean, don't we have two children who are in the same situation?
Yeah, that's what I'm trying to remedy, I guess. Because mother's not allowed to participate in the...
I guess what I'm trying to say is this, that it makes sense that when you've had a child who hasn't seen mother in 8 years, it's going to be difficult for that child to be in the same room with mom. He's not going to run in and run to her with open arms. And given the first attempt at reunification, it may make sense to follow your suggestion that the child come in without father, at least initially, but at least it doesn't make sense to me to expect that that's going to be continuing forever, right? I mean, and it seemed from the testimony and from the record that father did express that he wanted his son to have a relationship with mother. So he understands that. Maybe getting to that point is going to be a little bit trying. It's going to be difficult, but it's something that they can certainly achieve, even if they start without father. I guess I'm thinking of the point made earlier that both parties have taken positions that are not realistic, because when you ask a parent who's been the sole parent for most of the life of the child, you can't expect that parent to be completely open to here's the child and I'm going to stay out of it forever and always. I mean, that's...
Well, you would expect some kind of motivation, though, to at least let that child have a relationship with his mother.
Right.
Completely thwarted that. And just because the daughter is going to be seeing the son, it's not going to establish a relationship between mother and son. My client's got no way to show a modification later.
Well,
simply
but...
because the daughter sees the son.
But if the daughter is seeing the son with mother present, it gives, I understand that's not the case now, or the way the orders stand right now. I understand that. But going forward, if, and mother is, she's fortunate that she has this child, because that child could be her opportunity to reestablish a relationship with her first child. First maybe mom going in to have both siblings meet, and mom is just there passively and just reintroducing and taking advantage of that positive connection. And just, I guess what I'm trying to say is that you can't push these situations. It has to be something that's done subtle, and both parents need to understand that this is going to take time and that it's going to take participation, and that a 10-year-old is going to have some ideas about what they want, that sometimes you have to encourage them along. Sometimes you have to move them along.
And that's why we have therapeutic interventionists. These are professionals. They know how to do it. And both of these professionals here said because father wasn't cooperating, it's not happening. So don't give up. Reintroduce the reunification and make sure father cooperates.
Do you think your client can move away from simply focusing on dad's behavior if given an opportunity?
Well, if dad's behavior is colored with son's reactions ever since, I don't know how she could.
You don't think she can move past that and focus on her relationship with her son?
That would be part of the therapeutic process, I would imagine.
Because if she can't move past it, then her chances are
Of course.
probably nil.
Now, the father can't move past it either. He's got to allow the son to see his mother.
Yeah.
All right.
It's not a situation where there's been a continuous abandonment by mother. Again, those findings were incorrect. Substantial change of circumstance. Mom got custody of her daughter back. She's been through drug rehab. She's been clean for 7 years. She's gone through she's obtained employment. She's self-supporting. She's providing well for her daughter. There's no reason why the judge would find that it would be dangerous for her to have unsupervised visitation with her son. I don't have any relationship with her son. I mean, that sounds like a severance case.
Counsel, again, sort of, we're trying to pose some alternatives potentially for you counsel to consider. I mean, wouldn't it be also within the realm of possibility that you start in context of reunification, that there be a start with some supervised parenting time. I mean, that it, and then it grow from there, that it be very gradual and methodical at moving along, so that the child is not traumatized any more than necessary to bring this, if it can happen, to bring this about.
And that's why this order doesn't allow
Yeah.
for that.
Yeah.
This order says dad gets to decide. Dad is not a good decision maker when it comes to the best interest of his child. So that's why we're asking this court to reverse that order, so that we can get the reunification therapy started again and make sure father participates, so that we can gradually get this relationship built up again. You don't just give up like this judge did in this case.
So your position essentially is that the court did this kind of backwards by looking at the best interests and then determining that there was no significant or continuing modification, as opposed to determining first whether there was a change of circumstances, and then looking at the best interest in coming to whatever conclusion the court would come to.
See, what the judge was doing in this case, he was looking at the best interest factors to see if there's any change of circumstances in those factors. And no, there wasn't. The child has a relationship with father and paternal grandmother. That's not changed. Goes to school in the same neighborhood. That's not changed. But if the judge had done the right analysis and looked at how mother has improved, how mother is not having unreasonable expectations, Mr. Willis, I believe it was, that said mother definitely wants to be a good mother to his child.
Well, on the unreasonable expectations, she did request sole custody of the child. Wouldn't that be unreasonable?
The transcript shows that she was asking for this therapeutic intervention to be restarted again, and even the best interest attorney recommended that. Gradually ramp up is the way that they usually change. So, no, it's not an automatic sudden thing. That would be unreasonable in the circumstance.
All right.
So, I've done the 3 minutes. I think I've consumed things on for a while.
Okay, counsel.
May it please the court, counsel, Dean O'Connor appearing for Reno Gonzalez, who is also present. I guess I'd like to start by saying that the judge in the case, Judge Herod, was appointed to the family court in 2014. So he was a judge involved in the case for almost 3 years when he made the ruling that is the subject matter of this appeal. I believe Judge Herod also has been a voice for adoption issues, so I think he's kind of an unusual judge in terms of parenting and knowing about parenting. I don't know if I want to say that this case kind of failed on a number of levels, and maybe we're all at fault for that. But the judge specifically said in the transcript, or at the end of hearing all the evidence, he said directly to Ms. Claudia Work, who was appointed counsel, I think Ms. Work would agree with me, this is a difficult case. This is not a simple case. As I can tell, because I read the order on the termination petition, meaning right for the attempt to sever mother's rights, but this is not a simple case. It was a very close call, and this case is very difficult and very close, and both parents need to know that. And mother made a number of attempts to try to reunify with the child.
How many face-to-face contact visits were there? How many face-to-face attempts?
Well, my knowledge, and I'm not the expert. My knowledge is that mother never really had face-to-face during the sessions with Ms. Gonzalez, who was the first appointed, or through Annette Ruskin.
Wasn't there one?
We're talking about child to mother. I think the question is.
Yeah, child to mother. That only occurred by accident, and the child got very upset and left the room. I believe that's in the record under what Ms. Morales said occurred.
Mm-hmm.
I'm not real certain in my own mind why it never got to the point where mother was actually face-to-face with the child, but it never happened. So we have a child basically that doesn't have a relationship with the mother.
And let me interrupt you for just a moment. Isn't it to be expected, counsel, that on the first face-to-face contact with mother after 8 years, most of his life, of not seeing her, it would not be the interaction would be, the contact would be difficult, and that the child may not respond positively to mom? Shouldn't we expect that?
I think that may be true in every case, but I'm not so sure it is. But I think that this child, it would be. Because he was saying, and it's in the record to each therapist, both of them, that I don't want to be in the same room with them.
Right, and my question
I
is,
don't want to participate in the process, really.
isn't that to be expected when a parent has not been in his life for so long? He knows he's being raised by grandma and dad, and mom is somewhere out there in the world.
I think, I agree it's probably generally the case, but I've seen children that don't take a hard and fast position against a parent, because most children want to be involved with a parent, even if they haven't seen the parent for extended periods of time. It's normally the parents that cause the problem, not the child. But in this particular instance, this child is a straight A student and is very vocal.
So what would cause this child to not want to meet with his mother, whom he hasn't seen since he was 2?
Well, again, that's a problem with this case. There really were no experts appointed, and nobody gave expert testimony for the judge to rely upon. I mean, I've been practicing almost 4 years, and when I first practiced in family court, we didn't have these experts.
So then, how can we really say that mother's parenting time would endanger the child's physical, mental, emotional, or moral health?
Well, the only evidence of that probably is the child has said, I don't want to be around mother. And number 2, when it occurred by accident, he got very upset and left the room. He didn't want any part of it.
Counsel, isn't what you just said, though, I mean, you've been around this for 40 years. I mean, that is prevalent in our society in so many divorces. I think we could take judicial notice that the kids get upset at one parent or another all the time. I mean, even in married families, that happens, and kids. So to the extent the court said the court made a finding that it could cause severe emotional distress to the child. I have 2 concerns with that. First, that's not the standard; it's would, not could. And then second, where is the evidence of the emotional distress other than the child's own? I mean, again, we don't have the child's testimony, but this is coming in through statements made to others or through reporting. I mean, do you believe the record supports that there would be severe emotional distress to the child?
In this particular case, yes, there's not a lot of evidence of it other than the child specifically saying, I don't want to be in the same room with mother. I mean, my experience is children normally don't say that. And
When they're bonded,
huh?
when they're bonded to a parent, they don't normally say that.
Yeah, that's right. But there is no.
But when they feel neglected, when they feel the parent has not taken care of them, then they would tend to have negative feelings towards that other parent. Or when they feel that that other parent is guilty of some wrongdoing.
I guess I should have looked at this particular instance, though, with Rosa Gonzalez, and I didn't look at it again because I don't remember specifically, but she wrote out what occurred, and it seemed like the child was crying, I think. It was not a simple death.
But I thought
Again, there's
Go ahead.
no experts.
It isn't, but okay, let's go back to the threshold question here is, did the court err in finding there have been no material change of circumstances since between 2010 and 2018? Material circumstances that affect the welfare of the child.
Well, this was at least the second go-around with this judge on that issue. The first go-around.
But let me ask you though, did anybody ever answer that question? Any judge? I know that there's, because these petitions started in 2012. That was mother's first petition. I mean, did any judge definitively say there has not been a change of material circumstances until Judge Herod issued this order?
I think that's true. His initial analysis was, after hearing all the evidence, which was, in our position, the same as what was produced in the second hearing. We had the same evidence, pretty much. That he didn't make a finding then. He basically said, let's do reunification or attempt reunification and ordered both parties to go through Horizon and see if they could make it work and reunite mother with the child. So he,
But I don't-
really didn't address that issue until his ruling in April of 2017, wherein he basically, I think, wanted to put down, because he said it was after long deliberation, he wanted to put down kind of his thought process of saying, well, even if I say there is substantial change in circumstances or continuing change in circumstances, is it in the best interest of the child really to do this? And then going back and saying, no, I don't find that it's in the child's best interest because of what's going on, and I don't think there's a significant change or continuing circumstances that justify doing it. Particularly when mother was asking for sole custody or even joint custody.
So then the finding with regards to substantial change of circumstances was made in order to avoid the reunification out of a belief that it was not in his best interest. Is that what we're saying?
To me, we have to look at the procedures and the pleadings. I mean, mother can argue something else, but it was brought as a petition to modify decision-making, and that she wanted sole decision-making. It wasn't that she wanted supervised visitation or she wanted some other reunification.
Didn't her petition also include request for parenting time, at least? I thought it was all three. I thought it was sole decision.
I don't believe so.
There was no request for parenting time.
Well, she wanted equal parenting time, but she wanted either sole decision-making or joint with her having the final say. That's what the petition says, I believe.
But once a parent asks for parenting time, well, I don't know that a parent even has to ask. The statutes presume that all parents are entitled to substantial parenting time, absent a specific finding to the contrary, which all we have here is the court's finding about, and we come back around to what I asked you about a couple of minutes ago, the severe emotional distress finding. And if that doesn't have a lot of support in the record, then I'm wondering where we go from here as far as, I mean, again, I'll throw out the other, I'll go back. Is there any middle ground here to be sought in this case other than one party wants this and the other side wants this? And it seems like both sides are unrealistic in their expectations.
Well, my client testified, and it's part of the record, that he was for unification. The court specifically found that maybe he didn't have the capacity or the ability to do, is what the judge said. It isn't that he didn't want to do it. I mean, the record shows he took the child 20 times to Gonzalez to try to accomplish it, and took the child to Annette Ruskin. It isn't like he said, I'm not doing this. Plus, since, it's not part of the record, but since the ruling, my client has made overtures to say, well, let's get together, Star and this child, or the sister and the brother together, and let's do something. And mother's position is mother can't be there. And so we don't get anywhere because she wants to control how we do it.
Now, question back to the issue of whether there has been a material change of circumstances. The Superior Court's findings include that circumstances included removal of the child from mother. That's a static factor that will always be. And I'm not sure she can do anything about the fact that in the past the child was removed. That mother's continuing failure to remedy the circumstances leading to the removal. Do you believe that's supported by the evidence, that mother has continued mother's continuing failure to remedy the circumstances that led to removal. Do you believe that's true?
Well, in the sense that she could have done more, in my opinion, I think that is true, meaning.
Well, let's take it as...
Meaning we could have had a court-appointed advisor, we could have had counseling done.
Well, I don't think that quite answers the question. Let's take it one step back. Why was the removal? Why did it happen in the first place? Mom was on drugs, right? And what else? Mostly she was on drugs.
Well, I mean, I don't know if you looked at the police report or the CPS.
The home was in disarray.
But I mean, you know, the house was in a mess, and she was on drugs, and the children were out looking for food.
Okay, so she was on...
Severe case, and that's it.
Okay, so she's on drugs, the house is a mess, and the children don't have
It's a
food.
typical case in the juvenile court.
Can we say that those are still the circumstances attending now? Or at the time of the hearing before the Superior Court?
No, but she says, I mean, the issues, or the reason she says this should be changed on appeal is she completed rehabilitation in 2010, so that's a long time ago. So that's not a change of circumstance, it's been around a long time. The return of mother of the minor child that was done in 2011, that I don't see how that comes into play either because of the age of it. And that the older child now is to be reunited with his half-sister, I think everybody thinks that's well and good, but is that a significant change of circumstance? I don't know how you get there. And then the only other thing is my client's supposedly interfering, and I think the court said that's not true. I mean, he spent a lot of time, the judge, interviewing my client to get his position, and my client is saying, yeah, I don't have a problem with them reuniting, and that's on the record. So, and he took the child, and he tried to participate in the process as best he could. Unfortunately, that didn't work.
So then when we look at change of circumstances, what are we really measuring? Change from what circumstances to when?
Well, I think the problem is we don't have a relationship between mother and child.
Right.
Normally we have a relationship, and therefore the mother's spending more time, or the mother's involved. Like in this case, mother never got records, to my knowledge, of his schooling, never went to a soccer game. So we would have supplied the information. She could have gone. It's open to the public. So what is the change?
Okay, but that's my question. What are we measuring? Change from when? From when the child was removed from her care to now when she's petitioning the court?
Well, I don't think we go back that far because she filed a petition.
Why not? But I go back to my question. No court has ever ruled on this issue. She filed petitions in 2012, renewed it in 2013. Then there was a ruling came out in 14, and here we are. And then we have the 2016 petition.
I understand what you're saying, but
Well, I mean, what are we supposed to measure this
No,
against?
I agree with the concept that the judge didn't, but probably should have, when he did the 2012 petition, said, I don't see anything here that denied the petition, but we're going to do this instead. He didn't write it out that way. He just said, oh, we're just going to try to reenact mother and child.
Okay, well, going forward, if the court has the opportunity to revisit the issue of reunification, from your perspective, we asked appellant's counsel, from your perspective, what should that look like?
Well, you know, I don't, unfortunately, the child now is 11, just turned 11 a few days ago, and I don't know if it's going to work very well.
So you don't think we should attempt it?
Even if he's placed back in, I don't see how it works unless someone can convince him to change his mind. Because his mind is, I don't want a relationship with her because I don't have one.
Well, does your client agree that not having a relationship with his mother could be harmful to the child down the road?
Well, as I say, the record shows he's all for reunification. And the court basically found maybe lacks the ability to do it.
Okay, so your client is all for reunification, and we have an 11-year-old. I'm sure there are other things that this 11-year-old doesn't want to do. So does your client just give in every time the child decides he doesn't want to do something?
I don't think that's true at all. I think the issue is, how do we get this child to say, oh, I'm changing my mind? Because some, even as adults, there's
Not
people
easy.
we don't like and don't want to hang with.
Not easy.
Even our parents, some people don't want
Sure,
to hang with
sure.
because
Right.
of whatever reasons. So how do you get past that? Is my question. Especially unless there's counseling or whatever. And we have a new judge in this case. It isn't going back to Judge Herod if it goes down again. That wouldn't know all the history.
I guess it's important for the parties to remember that if this matter goes back and they have an opportunity to reattempt reunification, it's important to remember the big picture, to move away from blaming, and I'm talking about the parents, blaming each other for what happened and decisions that were made years ago, or for the child's now attitude. I mean, it's to be expected when a parent has been absent for most of that child's life, that the child's not going to be receptive initially, and the parent who has been absent needs to be patient in that process. When a person's coming out of addiction, they need to understand that everything that got put on hold and all the people who were burdened by your addiction don't now just receive you with open arms because now you're doing the right thing. This is part of the price to pay. So you have to be patient with all of those people in that process, including the child. But on the other hand, the other parent also needs to understand that even though there are some grudges that you hold because you're human and because this other person decided to live their life and do whatever they were doing for a while you were carrying the load, at the same time you have to remember that it's damaging for a child, even though they may not see it that way in the moment. It's damaging for them going forward to know that this parent is now sober, is now healthy, is now raising other children, giving love, affection, and support, but not to them. So those are issues that, even though it may seem easy to push the other parent away, in the long run, it's detrimental to the child. It's best for them to understand that their parent is there, is making an effort, loves them, and that's hard to do. Counsel is right. It's not an easy process, but it's a worthwhile process. And it takes effort, and it takes the parent who was there all along being the bigger person and saying, okay, even though I may not believe that this other parent deserves it, I know that my child deserves to have that other parent. And I'm going to do everything I can to encourage my child to go to these meetings, to go with a positive attitude, and do the things that we do when we're trying to coax our children to do things they don't want to do. But we get them to do them anyway because we know they're good for them.
To say, I know you're out of time, that we had, this court has looked at a case where an 11-year-old decided he didn't want to go counseling as the Department of Child Safety was trying to reunify, and the court granted it. And we reversed it on that basis just because an 11-year-old can't run the bus.
Well, I guess my only response, if you'll let me respond to that.
Yes,
Yes,
please.
go ahead,
No,
Judge.
please.
Is the child win to 20 plus times, and it didn't work the first time, and it didn't work the second time. So, and we're years down the road, so it isn't like he wasn't there.
Well, 20 plus times, but not seeing mom 20 plus times.
I
Well-
can't address why that didn't occur.
Okay.
Okay.
All right.
Thank you.
Counselor, thank you very much.
Thank you.
Thank you, Mr. O'Connor.
For the appellant, I don't know where the record it shows 20 times, but from what I recall from Mr. Wellesley's report, he wasn't bringing the child to the sessions. He wasn't allowing the child to participate. And Judge Cruz, you asked
Well, there was a
about-
number of one-on-one sessions with between the therapist, between Morales and the child, correct?
They were doing the sand therapy, correct? But as far as I know with Ms. Ruskin, I believe it was her report saying that father hadn't brought the child. I expected the therapist to bind the wounds, if you will, between mother and child without him participating at all. So there is a question about how many times that actually occurred. Judge Cruz, you had asked about how a child can react if you haven't seen the parent in over 8 years. There was a negative reaction here because, as Ms. Ruskin said, father brainwashed the child. Remember, this incident happened when the child was 1.5 years old. And Ms. Ruskin said, I don't believe that the child would remember any kind of abuse from mother over that long a period of time when he was that young. So, again, I have to attribute the father because the record is so clear on this. And I don't see why this is such a difficult case. Father should have been condemned for what he's doing. Should have been forced to do the reunification. Should have paid for reunification. We wouldn't be here if this reunification had occurred.
Well, counsel, going forward, I'm not sure that fanning those flames is going to get you too far to your goal.
No, but it will.
Yeah, it's just, I know. Yeah, and to that point, I mean, to what extent has your client tried to find out, I mean, from the school, to what activities the child is in? Has she attempted to go to soccer games? Has she been prohibited from going to soccer games, to visiting the child? I mean, to some extent, it's like, doesn't your client need to start a relationship, even from it's a long distance, by sitting in a car watching the child and what he likes to do, and getting involved in his life in different ways other than putting two people in a four walls in a small room and expecting, you know, everything to be all hunky-dory. All of a sudden, it's just not going to happen. So I think that both parties, I mean, as Judge Cruz said very well a couple minutes ago, both parties have to see this for what it is, and the rights, within the context of the legal rights that are granted to parents under Arizona law, and the legal rights that are granted to children. I mean, obviously, there's nobody trumps anybody here. Everything all has to work all together. And somehow, some way, the Superior Court, in my mind at least, I'm not sure about the other judges' view on this, but in my mind, the court has to find a way to give this another round, in my view. But I mean, I don't know. I'm not sure of what those details are, and then that's going to be up to counsel and the parents to figure that out.
But to answer your first question about mother's attempts, she did make attempts. She filed for the modification way back in 2012. But I think because the juvenile case was proceeding when he was trying to get severance, that case got stayed. So she had to file another petition in 2013, still actively involved in trying to get reunited with his child. And then I think I showed you in my brief where father had changed his address to a P.O. box. So mother lost contact that way. And does she have a right to expect him to provide information to her? Actually, he's required to. So she can't find him. She can't call him. She doesn't know where he lives. I don't know how she's supposed to.
I understand, but there's also the flip side that you sometimes you take the bull by the horns and assert your rights. That's all. Thank you, counsel, both for your arguments this morning. In this case, the court will take the matter under advisement and issue a decision in due course. The court will take a brief recess at this point, prepare for the next argument.